persons having any business before this honourable court now draw nigh. Give your attention and you will be heard. God save the King.
I begin this morning by acknowledging the traditional custodians of the country on which we meet, the Gadigal people of the Eora Nation. I warmly welcome all of you here today and those watching online, and particularly welcome Judge Gibson's family, who I'm sure are extremely proud of her success. Judge Gibson was appointed to this court in 2001. Her swearing-in ceremony was the 21st of May. More than 24 years have passed since that day, and Judith has decided to retire. Before joining this court, Judge Gibson had a very successful career, first as a solicitor from 1981 and later at the bar from 1987. She specialised in defamation and media law. Judge Gibson has been the bulletin author for Australian defamation law and practice since 1993, so that's 32 years. She has written countless articles on defamation law and the media and is a leading expert in that field, very often consulted by governments about legislative change. Her expertise has been acknowledged, not just in Australia but abroad. She has held multiple positions in the Ministry of Justice of the Republic of France. She has also authored publications in France and is fluent in French, Italian and Mandarin. English is her fourth language. Judge Gibson has been an affiliate at the Centre for Asia and Pacific Studies of the University of Sydney since 2009. She has been a member of the Reader Panel member for the China Journal of Comparative Law, published by Oxford University. There are many more committees and publications with which Judge Gibson has been involved, including as the author of the Defamation Chapter and Security for Cost Chapter of the Judicial Commission's Bench Book. With all these extrajudicial commitments, one wonders how Judge Gibson has time to do any of the work of this court. Well, she has. She is hardworking and has been one of the most productive judges. This is not just based on observation and reputation, but is a fact. Case law statistics as of September 2025 show that since records of published judgments were kept 4 years after Judith's appointment, this court has published 10,205 judgments in both its civil and criminal jurisdictions. Of that number, Judge Gibson published 739, or 7.2% of all of the judgments of this court. If one looked at the civil jurisdiction alone, Judge Gibson is responsible for writing and publishing 15% of all judgments. To describe her as prodigious in generating important judgments and precedents is a gross understatement. She has also served on several court committees, including the Policy and Planning Committee and the Technology Committee. She has been the defamation list judge for most of her time on the court and has often sat as civil list judge and childcare list judge. It is clear Judge Gibson has made an immense contribution to this court and to the administration of justice in this state. Indeed, the Chief Justice of the Supreme Court of New South Wales, the Honourable Andrew Bell, who was unable to be here today, said in a recent letter to Judge Gibson, "You have had a long and distinguished judicial career, and I both acknowledge and thank you for your significant contribution to the administration of justice." On a personal note, Judge Gibson is well loved by her colleagues. She always engages enthusiastically. She has amassed an extensive collection of original sheet music covers from the mid-Victorian, Art Deco and World War II eras that have adorned the corridors of the John Madison Tower. So impressive is her collection that in 2006, the Art Gallery of New South Wales visited the court to view them. Judge Gibson, you will be greatly missed by all of us, but can I say how pleased I am that you have accepted a commission as an acting judge, but hope you can enjoy more downtime and travel time moving forward. Finally, I would like to read from Judge Gibson's speech on the occasion of her swearing in. Quote, "In our legal system, we have justice on a pedestal with a blindfold holding a pair of scales. When I was in Paris, I went to a courtroom where they had a wonderful painting of Justice, which showed Justice as I like to see her. She had gotten down off her pedestal and she had taken off her blindfold and she was sitting at the back of the court and she was watching the judge very closely. Indeed, I like to think that when I am in court, I will be watched in the same way, not only by Justice, but by members of the community, and that I will be able to dispense justice fairly, efficiently, and speedily. Judge Gibson, you have exceeded even your own expectations. I now call on the President of the New South Wales Bar Association, Mr. Dominic Toomey, to speak on behalf of the Bar.
Please the Court. May I respectfully adopt, Your Honour, the Chief Judge's acknowledgement of the traditional owners. It is my privilege to speak for the Bar on this, the occasion of Your Honour's retirement from the bench after 24 years of service. That is indeed a lengthy stint. Your Honour attended Strathfield Girls High School before going on to the University of Sydney to undertake a Bachelor of Arts with honours, a Bachelor of Laws and a Master of Arts. On the 14th of July 1978, Bastille Day appropriately, you were admitted as a solicitor and from 1978 to 87 worked first at Allens and then at Phillips Fox. On the 10th of April 1987, Your Honour was called to the Bar and in 1992 you were also admitted to practice in Ireland. Although as a practitioner Your Honour worked in a number of different areas, your main area of practice before your appointment to this court, as we've just heard, was in defamation. Your Honour's involvement in defamation work, both as a legal practitioner then as a judge, led to your contributing, as we've also heard, to significant publications in that field. Only a few of many examples are as editor of Aspects of the Law of Defamation in New South Wales, as editor of Australian Defamation Practice and Procedure, and as a contributor to Halsbury's Laws of Australia. Your Honour first became interested in defamation law when a child. You found a book in the family home called Hatred, Ridicule or Contempt by Joseph Dean, published by Penguin Books. You were enthralled by the stories. Reading this book led you to the Liberace case concerning a now long dead gay American pianist and entertainer who successfully sued the UK Daily Mirror for suggesting he was gay. Homosexuality was then still illegal in the UK. Your Honour later told a journalist that from the time you read that case, you realised you were destined to become a barrister. Years later, after many years of practice, describing your time at the Bar, Your Honour paid tribute to the late David Hunt, Chief Judge at Common Law, and the late Justice David Levine, from both of whom you learned a great deal about the law of defamation. Your Honour was appointed to this court on the 21st of May 2001 and presided in the court's civil jurisdiction for over 24 years, as we've heard. Much of Your Honour's work was, unsurprisingly, in defamation, and for much of your time as a judge, Your Honour was the defamation list judge. When you were born, Your Honour had either the fortune or the misfortune to be given the name Judith, sometimes shortened to Judy. Much of Your Honour's time on the bench coincided with an American TV show called Judge Judy, a reality show about a no-nonsense judge from New York who presided over all manner of disputes and had the power to award damages. Thus, when, as it often did during Your Honour's 24 years on this bench, the press referred to one of your more colourful cases, they would sometimes take the liberty of calling you Judge Judy. One wonders whether Your Honour considered bringing an action. Oh, it must be acknowledged that the American Judge Judy was seemingly well liked, even if only for her entertainment value. Your Honour presided at an interesting time in the history of defamation law in this country. When you commenced practice, A defamatory meaning was usually conveyed in a newspaper or magazine article or on a radio or TV program. But during the 1990s, in the decade before Your Honour's appointment, the internet became a significant part of our everyday life. With the internet came new ways of publishing defamatory material and, with them, new legal arguments. Your Honour was appointed to this court the year before the High Court decided Dow Jones and Gutnick, holding that Australian plaintiffs could sue for defamation on the internet irrespective of the location of the defendant who uploaded the publication. Also significant was that Your Honour's appointment occurred just 4 years before the relatively Uniform Defamation Act was passed by Australian states and territories. And now Your Honour's retirement comes just 4 years after the law in most states was amended to permit a successful plaintiff to recover damages only where they could show serious harm to reputation. In 2017, Your Honour wrote an article for Defamation Case Law Analysis and Statistics. You noted a growing problem in defamation was that claims based on publication on the internet, emails and social media had become more common than claims against traditional media defendants. This meant ordinary people increasingly found themselves defending actions in a complex and sometimes expensive area of the law. A year later, in the Australian newspaper, Your Honour again noted the need for law reform, observing that ordinary people could not afford the fees in defamation cases. You called for a courageous response to this problem, arguing that freedom of speech in Australia would not be served merely by changing the typewriter ribbon when a genuine cyber age reboot was required. You emphasised that the greatest cost to the community was the increasingly feral, Your Honour's word, nature of defamation claims. The most recent significant reforms have undoubtedly been influenced by Your Honour's agitation for change. When Your Honour was first in practice, those in the defamation field often relied on unreported judgments, indeed judgments often totally unknown and almost unobtainable for those whose practice area fell outside defamation. Shortly before Your Honour's appointment, case law arrived, making judgments of the court much more accessible. Members of the public not used to reading judicial decisions would perhaps be surprised to read a case such as Burrows and Hooder. If they did, they would see that in the course of your work, Your Honour had to consider such matters as, what is an emoji? This was apparently the first time in Australia a court was asked to rule on the capacity of an emoji to convey a defamatory meaning. What is an emoticon? What is the meaning of the emoji known as zipper mouth face? And is it appropriate for a judge to determine a meaning based on an emoji without the benefit of expert evidence? Your Honour's reputation as a stickler for English grammar was also called on in this same case, where you considered briefly whether an emoji is a collective noun or perhaps should have an S added for its plural form. You'll all be relieved to know, I'm sure, from Her Honour's observations in the case that the emoji has now largely replaced the emoticon. Your Honour's contribution to the case law, however, has gone well beyond your study of emojis and emoticons. In recent times, Your Honour seems to have developed an expertise in cases about dogs. In one such case, Zimmerman and Perkis, Your Honour gave the first published judgment on Section 10A of the Defamation Act. This is the earlier mentioned provision which now requires a defamation plaintiff to prove serious harm to reputation as an element of the cause of action. The case concerned dog grooming implements. Mindful that a so-called swearing out is not an occasion of absolute privilege, I shan't expand. The case is on case law. And another of Your Honour's recent dog cases required you to consider the services provided by a pet detective. No study of defamation cases can be quite complete without considering the contribution to that part of the law by politics and politicians. Those of you here old enough to recall the Lionel Murphy prosecution will understand when I tell you that in 2015 Her Honour had to consider a number of imputations concerning the late Morgan Ryan, a former solicitor who in the 1980s was known as High Court Justice Lionel Murphy's little mate, an expression made famous when the late Justice Murphy ultimately successfully defended charges against him of attempting to pervert the course of justice. Other cases heard by Your Honour have called on you to consider matters of fashion, especially concerning hairstyles, it seems. In a recent case, an imputation pleaded by the plaintiff but later struck out was that he deserves to be an object of ridicule because of his mullet. Of course, it would be quite wrong to think of Your Honour as a one-trick pony. Your position in the civil jurisdiction of the court has seen you deciding a broad assortment of cases, many involving personal injury. Your Honour acted as the approvals list judge for many years, hearing applications for the approval of settlements in cases involving plaintiffs, very often, but by no means always, children, who were, by reason of age or disability, unable to be left entirely to striking their own bargains. That list was a great source of work for the bar, and Friday mornings would see a packed court of barristers there to collect a fee before repairing to a favourite restaurant. On one such day you saw my colleague, Dallas Morgan, eagerly awaiting Your Honour's attention. You asked him whether he too had an infant approval. Yes, Your Honour, came the reply. My infant is 89 years old. Beyond law, Your Honour has a significant interest in the arts, as we've heard. And as we've also heard, you once persuaded the then Chief Judge to allow some walls of the John Madison Tower and passageways through to the Downing Centre to be hung with framed works of art, many consisting of the covers of French sheet music. The exhibition was promoted by the Art Gallery of New South Wales and became quite well known outside the court buildings, so that some art lovers and collectors quite unconnected with the law would ask for and be given a guided tour. Because Your Honour speaks French, Italian and Mandarin, you're especially qualified to serve on committees focused on comparative law. Among many other appointments, you were appointed by the Ministry of Justice of the Republic of France to the Conseil Scientifique du Droit from 2004 to 2007, and to the Fondation pour le Droit Continental from 2008 to 2016. By all accounts, although you only began to study Mandarin in 1990, you became as accomplished with Mandarin as you had with French and Italian. When interviewed by a journalist for The Australian in 2018, Your Honour admitted to watching TV shows broadcast in Chinese, one of your particular favourites being a Mandarin version of Antiques Roadshow. When Justice Blanche was Chief Judge, he had an excellent relationship with some members of the Chinese judiciary, and for many years led groups of New South Wales judges on fact-finding missions to that country. Your Honour was in one of those groups in 2004. You were walking on the Great Wall and heard a Chinese man singing an ancient folk song you had learned in your Chinese studies in Sydney. You stopped to talk about the song to the singer, who was so delighted with the experience that he insisted Your Honour sing along with him. Sadly, time is unlikely to permit a rendition today, though there's always morning tea. Judging by how Your Honour has lived your professional life, I predict Your Honour's retirement will not be idle. It has been suggested to me by one of your colleagues that you plan to do something around space law. I seek my children's forgiveness in advance for this, but I assume that that won't involve acting for Kennard's Storage. As a colleague, Your Honour has been described as exceptionally generous and curious, and always concerned with the well-being of others on the court. Your presence and your learning will undoubtedly be missed by many here. The Bar wishes Your Honour well. May it please the Court.
Thank you, Mr Toomey. I now call on the immediate past President of the Law Society, Mr Brett McGrath, to speak on behalf of the Solicitors of New South Wales.
May it please the Court. Chief Judge, I too would like to acknowledge the Gadigal people of the Eora Nation, the traditional owners of the land on which this court stands, and pay my respects to their elders past and present, and extend those respects to any Aboriginal and Torres Strait Islander peoples here today. We are witnessing today the end of a recent high watermark of judicial judgments in the District Court of New South Wales. To echo the sentiments of the Chief Judge, one of the most prolific publishers of written judgments this court has ever seen. To help reduce the work pressure, I believe Your Honour will be at least taking the whole of this Monday off and back on Tuesday to take up your commission as an acting judge of this court. Without hyperbole though, it is likely that Your Honour has contributed the most written judgments to this court since 1858. However, given electronic records began a little later, in 2005, unfortunately and luckily I could not verify this statement. I do know for certain that they have been consistent in the clear, balanced and efficient legal reasoning solicitors relish. Their quality and quantity have also been persuasive for the public's access to legal decisions too. In this, Your Honour has set an example that goes far, far beyond the end of your swearing-in speech in 2001, where you hoped to be able to, and I quote, dispense justice fairly, efficiently and speedily. As comfortable with detailed discussions of the grammar of Mandarin as 19th century French criminal cases, to theology, and on through to the work of, say, Voltaire, or equally, Redfern Legal Centre and the Women's Legal Centre, Your Honour has a detailed memory that is encyclopedic, and yet wonderfully more alive than that may suggest. As we have heard, recent issues and recurrent problems in defamation law have been a perennial source of fascination for Your Honour. Before recent reforms, it was pointed out in the Parliament of New South Wales that between 2014 and 2018, there were 268 references to defamation law in the decisions of superior courts in the United Kingdom, compared with 577 in Australia. And 312 of those 577 references came from New South Wales alone. As a consequence, Your Honour sat on the Experts Advisory Committee for the Department of Justice, which produced the review of model defamation provisions in 2019, alongside the Honourable Justice Lucy McCullum, the late Sandy Dawson SC, Professor David Rolfe, the Honourable Solicitor General of New South Wales, Michael Sexton SC, and working with the exceptionally experienced Deputy Parliamentary Counsel, John Leder. Before this, the pace of reform led Your Honour over the years to some pithy observations about the issues underpinning defamation law. One of my favourites was, to quote, "Too many legislators are still trying to work out how to program a VCR." As Your Honour once rightly observed. Your Honour would know, having subsequently written the book on the subject, the Civil Trials book, bench book on defamation for the Judicial Commission of New South Wales. And here, various brother and sister judges have informed me of how capable Your Honour has been, not just legally, but also in recognising the good work, good talent and good people around you, whether they are interns or senior judicial officers, whilst also remaining, in the words of one, a quiet achiever and yet fearless, despite how easy it can be to be quelled, someone who understands what justice demands. One informant noted Your Honour has a mind that is never idle, constantly curious and always dignified, representing the best qualities of a judge. That curiosity also meant Your Honour often realised the technical needs of the court well before anyone else, and the scientific and technological horizons affecting law before many others. Indeed, judicial officers credited Your Honour as helping move the court into the 21st century. With a dry sense of humour, this led Your Honour to once write, and I quote, there are plenty of examples of technological elitism in Australia, such as the former New South Wales Attorney General's announcement on 21 December 2012 that he would ban laptops and smartphones from courts to stop tweeting and social media. From the perplexing to the sublime, Your Honour has also brought international connections to the District Court of New South Wales. Few judges speak French and Mandarin, with extensive government appointments to the French Ministry of Justice, through to co-editing a text on economic law reforms and development in Asia with a French Superior Court judge. And yes, unlike Mr. Toomey, I'm avoiding pronouncing any of the titles in French in front of Your Honour. Fair legal costs have been another point of focus for Your Honour, from a citizen's access to justice through to the efficiency of courts. This was no doubt a major part of Your Honour's motivation in becoming a member of the Cost Assessor Rules Committee, representing the District Court, to help regulate the practice and procedure of cost assessment and reviews, and to do so alongside representatives from the Supreme Court, Bar Association and Law Society of New South Wales. Whether hearing matters involving Salim Mahaja or the missing apostrophe case which made the New York Times, Your Honour has dealt with a huge variety of matters. It includes the first case to consider whether emojis can be defamatory, as we have heard from Mr. Toomey. And to make it clear, they can, in case anyone's finger is hovering over one right now. But, of course, seek independent legal advice. And in these matters, it has been apparent that in consideration of evidence, submissions and the law, a high tensile compassion for those appearing, plaintiffs or defendants, has been alive too. Your Honour recalled once considering a witness who seemed as if he may be difficult for the court. That is, until you saw him in a moment, no one else would have seen, clutching a photo of his family and children, clearly needing their support. Moments like this are a reminder not to avoid the judicial oath to act without fear or favour, affection or ill will, but that there are many ways to understand people should we take the time to pay attention. One solicitor we spoke to also recalled that Your Honour was always ready to progress the law, including on one occasion when a plaintiff sought an order for substituted service upon an international hip-hop artist known as Flow Rider via his Facebook page. Having studied the posts made by Mr. Rider, Your Honour was satisfied that the page was authentic and allowed the plaintiff to serve via that platform. I note that order was later set aside by the Court of Appeal, who made no criticism of Your Honour's progressive instincts or ability to recognise Flow Rider's hooks and beats, but ruled that the order was beyond the power of the District Court. Your Honour has been a friend of the Law Society of New South Wales through all of this, with close cooperation with our solicitors and staff in addresses to the profession across many, many events, and even, as some staff have recalled, as guiding lights in their own lives. Across all of this, on behalf of the Law Society, sincerely thank you, Your Honour. I close this submission with a reflection from a solicitor in private practice. He recalled that during COVID, Your Honour joined a panel he organised for the Communications and Media Law Association. Always methodically prepared, Your Honour brought along a dossier of papers and submissions on defamation reform law, which dated as far back as a submission made on behalf of young lawyers at some point during the post-war era. This lawyer introduced Your Honour to the AV specialist who was pinning a lapel mic onto your blazer and said, "Ben, this is one of our panellists, Her Honour, Judge Judith Gibson." Ben asked, "Does anyone call you Judge Judy?" Your Honour set Ben with one of those raised eyebrow stares that are well known by practitioners pressing an unsustainable submission, before graciously conceding, "Sometimes." The stated objects of uniform defamation legislation right across Australia is to protect individuals from unjustified attacks on their reputation, while also safeguarding the public interest in free speech and open discussion. With wisdom, experience, fairness and humanity, no one has done more to strike that balance than the retiring defamation list judge in the District Court of New South Wales. Your Honour, on behalf of the Solicitors of New South Wales, thank you, as the court pleases.
Thank you, Mr. McGrath. Judge Gibson.
Well, I thank everyone today for coming here. I'm overwhelmed to see so many friends and colleagues. I have a lot of people to thank, but I'm going to try and keep this short because I've got to finish the judgment left over from yesterday. It's the first ever privacy tort, so it's a pretty exciting judgment. As the Chief Judge has noted and the other speakers, I have always been interested in defamation law, and in a way I couldn't have picked a better time to be a student and a young solicitor than the late 70s and early 80s, because that was the glory period of all the great jury orators, and I was able to nick in and sit in on some of the great jury trials and hear the speeches of long gone experts in jury manipulation. I wasn't there for one of the more famous ones. I was at law school with Madame Lash, the leather-clad dominatrix who sued for defamation, so unfortunately I never got to hear Clive Everett famously say that all that Madame Lash wants, members of the jury, is a fair crack of the whip. I did miss that, but I did, however, get into the last Junior Morosi trial, where I carefully sat at the back of the court, which is not a good idea if Tom Hughes is there, because his habit of addressing the back of the room is extremely unnerving if you happen to be sitting there. At Allen's, I had my first ever defamation client given to me by my dear colleague Philip Esler, and this was an ecumenical monthly magazine called National Outlook. They were very biblical in the sense that their finances consisted of the widow's mite. I was all they could afford. So I sent some stern letters to the person who'd threatened to sue this respected religious publication for defamation, and to my surprise, the plaintiff dropped the case. Looking back, though, this unexpectedly good result was probably more likely to have been the result of constant prayer from the members of the board to a higher court than from anywhere else, as opposed to my rudimentary defamation skills, but nevertheless, I was hooked. After the case was successfully resolved, Philip Esler said to me, "You know, they quite like the way you write. Would you like to write film reviews and replace our film reviewer, who is a very respected media academic?" And I said, "I don't know anything about films." And Philip said, "Look, you get free tickets." So I said, "When can I start?" So I got to sit on the board and occasionally look at the other articles from a point of view of defamation, which meant I accidentally kept up with some of the great issues, the great moral issues of our time, which I think very often underpin what we're looking at in terms of relevant legal principles. I was admitted to the bar in 1987, and the Bar Association keeps some very useful records. It recorded that I was woman barrister number 160. So to put that in context, my colleague Anne Ainsley Wallace, who's somewhere down there, she was actually woman number 60, although admitted in 1978. So as you can see, we were part of a great surge of women. Well, great compared to what prior to that. The last 40 years there'd been hardly any. And you see a situation where women were coming to the bar in more recent numbers. So by the 90s, there were a few, but it was still a very small proportion. There's a wonderful description in the Chief Justice's recent paper on technology and AI, where he described what his chambers were like in 1995 when he first came to the bar. That is, there was no internet, no email, no Ostley, and very few women colleagues. But I was a bit luckier than that, because I went to 13th floor St James Hall, where women and technology were in abundance. So in 1995, I was able to follow Jane Needham's lead, and with her help and some trepidation, installed my first computer. I still remember the excitement of getting my first email from Jane, a mere room away, but it was an email. And that was followed immediately by the disappointment of realising I didn't know anybody else to send an email. Fortunately, Michael Green joined our chambers soon after, and in between setting up Barnet Jade, a wonderful service, and his own busy practice, he had us all up and running, and he also configured the computer I took to the bench when I went onto the bench. So I arrived with this very impressive, sleek-looking piece of machinery which everyone in IT was very anxious about. Not only was I lucky in being a member of such a wonderful and friendly floor, but I also had the good fortune to appear before those eminent jurists David Hunt and David Levine. I could not have had better mentors. So I had the ideal life. I had chambers next door to people like Michael Sexton and Terence Tobin. Clark Chris Veenstra had been David Levine's associate, so I could talk about defamation 24/7 if I wanted. It was not, however, just defamation. One of the last cases I did before I was appointed was the Lena Game Meets decision on privacy in the High Court. I'm very pleased to see, as my career ends, finally something has been done about the tort of privacy, although it might not be if I don't get on and finish that judgment this afternoon. I have had the good fortune to participate in a number of law reform initiatives, but I want to especially mention the work I did for the Experts Committee with some wonderful people some of whom are here today. In fact, all but one are here today. First of all, there is Lucy McCallum, the Chief Justice of the Supreme Court of the ACT. Then there is Michael Sexton, the Solicitor General. Then I also see David Rolfe is here. And then John Sackar, of course, came in a little bit later. John Leder, the wonderful drafter of the 2005 legislation. And finally, of course, the late Sandy Dawson, who worked for us right up until the end. We certainly had many critics while we were doing it. There were people who said we were selling a pup. There were people who said the savings provisions wouldn't work. There were people who said serious harm, it'll just waste everyone's time, but it hasn't. The statistics are now in. There's been a substantial drop in cases, and at last we have a situation where it's looking more and more likely that defamation cases will be not brought by people having backyard arguments, but by people with genuine and serious issues for the courts. The result has been due in part to the excellence of judges, not only in this jurisdiction, but also in other jurisdictions. And can I especially thank my colleagues in other courts, Judge Julie Clayton in the Victorian County Court, Peter Applegarth in the Queensland Supreme Court, for the degree of collegiality and assistance we've given each other over the past decade in particular. I want to thank the Chief Judge for her contribution, support and encouragement generally, but I also want to thank her predecessor, Justice Price, who achieved so much in terms of adding technology to this court. He set up a special technology court, which was really quite unique. It's a technology committee for judges in all the courts around Australia and New Zealand at the district court level. And the idea is that we will exchange ideas and look at initiatives that are, if you like, Australia-wide and not merely statewide. And I'd like especially to thank Judge Sam Marks of the Victorian County Court in this regard. Yes, it's true, I've spent a lot of time in very nice countries overseas, sitting on committees where I was able, because of my language skills, to make a contribution. And I would like to thank the two judges who did assist me, but rather than referring to who they are, I'll just thank a couple of people. One of them is Professor Ma Hongjun from Zhengfa Dashi in Beijing, and the other is my friend Marilise Ebrard at the Notary Institute in Henan. And can I also thank my Chinese teachers over the past 30 years. I think 4 or 5 of them are in the audience today. They'll be no doubt reminding me that I don't have any excuse for not doing my homework now. Although I'm retiring, I do hope to be able to assist the court from time to time as an acting judge, but I particularly want to thank my colleagues over the past 24 years. The judges in this court are an amazing group of people. I once had the privilege of going to the jail with a group of judges, which included Bob Belair. And I was very new. I'd only just been appointed. And when we arrived there, of course, I thought prisoners of people were all locked up. And I was very anxious when I suddenly saw this enormous, great mass of people coming towards us. I said, what's happening? Is this a prison riot? And so the warden came up and said, look, it's Judge Bob Belair is here. And they're not just prisoners. They were the wardens, they were everyone, because the man was a legend. He was a remarkable man. And so many of my colleagues lead extraordinary lives where they make tremendous sacrifices personally and professionally to get their job done. Not enough good things are said about how hard they work. And also the court staff, our amazing library team. We don't need AI. We've got the library team. They're amazing. Then there are the wonderful people in the registry, such as Jane Dunn. The most important person in the court is, from the judge's viewpoint, the judge's associate. And nobody's been luckier than me in terms of having wonderful associates. I particularly wanted to thank my associates Frank Yang and Wendy Zhang, who've been with me for the past 5 years. Wendy started working for me just before the pandemic hit, and not only was she a brilliant organiser, but her energy and her enthusiasm were just inexhaustible. She was always able to grasp the main issues, and I don't think I could ever have got through all the reading for the expert committee without her help and assistance. Frank Young came to me with a brilliant academic record that included the Equity Prize, which is a bit wasted on me. But his skills included an ability to analyse legal issues that helped me express my ideas more clearly. He returned to China earlier this year, but he's come back specially for my retirement, and he's here today. I thank him and I wish him well for the brilliant career he's going to have as an academic. After Frank left, Wendy Jang, my previous associate, took time away from her busy practice as a solicitor to work for me for the last 6 months, and she will now return to work for her boss, the solicitor Judy Jar. I had the pleasure of meeting Judy at the recent Lawyers Weekly Award, where she was one of the finalists for Partner of the Year, and I want to say how grateful I am that she loaned Wendy back to me. But it's not just me, the whole court will be sorry when Wendy goes back, because there's a long file of people coming to see Wendy all the time because they all say, Wendy will fix it, Wendy will know, and she always does. These are difficult times for lawyers and judges, as overseas events demonstrate, and when you see these brilliant, hard-working, enthusiastic young people, I feel confident that lawyers and courts can take on the big issues which confront not only Australia, but the world. Finally, and most importantly, I have my family. My family and friends have always been there for me. My sister Helen in particular has been a constant support, as has her husband Gary, and there's just no way to thank them adequately. As I make plans for my retirement, and I've got a lot of plans, I can tell you that now, it's good to know there is family support. Retirements are a mixture of happy and sad. Happy because I have many plans, and sad because some of the people dear to me who came to the swearing in so long ago are no longer with us. Being on the bench can be a very lonely job, and ultimately what gets you through it is knowing that you have support. It's the quiet happiness of home life that matters most. And that's what I think Voltaire sought to convey in Candide when he said, you just have to cultivate your own garden. I won't say it in French. But 24 years, although a long time to be on the bench, is now gone. It's now time for me to start enjoying my life in my garden. So I'm going to finish by inviting everybody out for a cup of tea and a biscuit, hopefully a chocolate one, in the foyer outside. Thank you very much.
Thank you, Judge Gibson. The court will